I want to believe that my former professional advisor, LDC, is misconstruing it with the application of the law 169(1)G and 2129 of the UPDF Act to Section 169(2), which is general in application that gives 30 days. But Kizza, Eron, being an advocate, it puts him under a specific provision of 169(G), 1G, and 2129 that gives a maximum sentence of 5 years.
So you are saying actually the court was lenient?
Absolutely. Okay. Actually, the court martial was lenient, considered his.
Do you speak to that in your reply and arguments?
Yes, my lord.
Thank you, sir. Yes.
My lord, I want to refer to Order 3 of the Supreme Court decision number 2 of 2021. Honorable Kabazigro, Attorney General versus Honorable Kabazigro. It said that this judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentences.
Remove the word save and put except.
Except.
Except
where?
Make
it easier. Except where the conviction and sentences are being challenged in courts of law.
So, is it your view that the conviction and sentence of the person in court
were affirmed? We are affirmed by the Supreme Court that they carry legal basis and are effective.
They are effective for as long as they have not been challenged.
Yes. Now, and even the challenging, the Supreme Court did not dispose of the challenging. Yes. It says it did not. It means that where the challenge is ongoing, the trial can continue and be challenged.
So for me, what I'm raising at this point is this decision properly.
This matter arises from a conviction, it arises from a matter which is criminal in nature, and the right forum would have been the criminal division.
So who would have been the respondent if not the AG?
Uganda, the state of Uganda.
Represented by who?
Uganda would have gotten its representative. Uganda has many institutions which are in charge of its defense and prosecution.
So you are saying you are not so sure.
I'm very sure.
Uganda, but we don't know a particular agency, institution.
Your Lordship, Uganda is alive and it's known.
But this court is also Uganda.
Yes, my Lord. We have, for example, the office of the Director of Public Prosecution.
So that's what I was waiting for.
Yes, my Lord.
So That's the Director of Public Prosecution.
Because
Is she
the order,
possession of this file, the subject of the conviction?
my lord, she doesn't necessarily need to be in possession of this file. As long as a citizen of Uganda is aggrieved and has sued the state of Uganda, the fact that you have sued the state of Uganda, that file would be put to the attention of the office of the Director of Public Prosecution. Unless the applicants choose who should be, I think, which I feel that in this particular case, he chose a preference of who should be the respondent.
I've got you. So,
my lord, it is my submission that this application is misconceived. Mr. Eron Kizza is serving a lawful sentence, which was never set aside by the Supreme Court. He has all the remedies available for him. He can appeal. He can file an application for revision if he's aggrieved. But coming to civil, apply for an unconditional release, it's absurd. This is not the right for us.
We started with 2 points in 1 minute. Then we call it.
Yeah, but well, I'll take your points. Then I see whether they cover the.
Because the rest of the information is in here. I've already wrote the very detailed.
Yes, my lord, I can take your 2 points. Yes.
I want you to make the 2 points.
Oh, you want me to make 2 points?
I thought you wanted to.
Yes, in reply, I think there should be clarity here. My lord, the matters before you do not constitute a criminal appeal or a criminal revision. If they did, then we would concede that they should be before the criminal division. The matters before you are matters of human rights enforcement, are matters of habeas corpus, which is a non-derogable right of enforcing the right to liberty. They are properly before you, and the proper respondent is the Attorney General. What Eron Kizza seeks is not to interrogate his sentence or even the process of the trial. What section was he convicted under? What sentence should have been imposed? Those are not the arguments we are making before you. Our argument is very simple. Eron Kizza is a civilian. He was convicted, albeit without even a proper trial, actually without, by the General Court Martial. He appealed that conviction to the Court Martial appeal, which is still a court of law. And the Supreme Court has said, and we want the words of the Supreme Court given life, that if you have been sentenced, convicted and sentenced, the nullification of the proceedings through which you were processed in the general court martial has a retrospective effect. If he had not appealed, then he would have served his sentence. But as long as he appealed, the nullification of the proceedings acts retrospectively to restore his freedom.
I get it now, because the Supreme Court could have said, the court martial appeals, please expedite the appeals.
Yes.
And they said, no, go to, created a bypass to the civilian courts.
Okay. Yes. So it is that simple point. We don't have to labor it. It's a human rights matter. It's a civil matter. It has nothing to do, because you see, revision would mean that you go to the criminal court, civil criminal division, to do exactly what the Supreme Court said. But the Supreme Court has already said this is the wrong court to try you, the civilian. And if they have convicted you and you appealed, get your freedom. My Lord, Counsel Eron Kizza comes before you as a civil court to enforce his right to liberty. It's our prayer that this court restores his liberty by ordering his immediate and unconditional release. We so pray.
So I think this is sufficient. Monday at 2:30, you'll have a ruling. You don't have to bring Eron unless, yes, sir. Okay. What I normally do, Mr. Eron, I normally share decisions on lawyers, but I will honor your request. So, yeah, okay.
Kale omulamuzi yongeddeyo okuwa ensala we wabbalaza ssaawa 8 era tuba tusuubira okuba nga Eron afuna ensalawo ye oba ateebwa oba ateebwaye waliwo application okusooka yateekamu n'okusinziira saidi ya saidi ya gavumenti ekizudde nti application zino zirimu enagala okufaanagana, so ne basaba nti bagiwenge oba bawakanye empoza zange zenjawulo so bwe kusalawo nti amateeka abenjuyi zombi era okuwa ensala ye ensonga omanga ye Eron Kizza ssaawa 8 asooka abantu endala
They must never stand in any matters of activism and defenders of human rights. Yes. Kizza is on record for hijacking cases like mine. Kizza is on record for sending a dying, a nearly dying Kakwenza to prison. As lawyers, Tumakunga, please resist judges like Kizza in matters of human rights. Full stop.
Even not information. Nancha, she's the husband of the prosecutor. She's the wife of the prosecutor of the ICD court.
Nancha stop persecuting.
Yes.
In Nyandula and Ingrid Finawe and other activists.
Not only.
Nancha stop persecuting.
Say no to Nazis judges.
We are tired of.
Activists say no to Nazis judges.
We are tired of.
They look like people never appear in any court. Say no to Nazis judges.
No, your husband works in the guy is a prosecutor in the ICD court. Nancha, stop foreign civilian, take them as military rules. Stop it, Nancha.
Say no to Kizza.
Say no to Kizza.
Say no to
Eyakategatako okutegeeza nti tuli wano ku kkooti enkulu Equator Awards Kampala yakize okufuna ensalawo y'omulamuzi Kizza omusango ogwagwalira Kizza awakanya okubanga ali ekitalira mu bumenyi bw'amateeka naye okusinga kufunamu eno rulingi erimusasuliza lwansonga si omulamuzi yandibanga simutegefu kuwa rulingi ye mu maaso ga bannamateeka instead ayinza okugiweereza ku email. So tuli wano okusobola okulaba nga tulaba oba oli awo kituukirira bafuna rulingi obayo. So eyo embeera y'ekyali ndaba twebaza okubanga olinaffe era otugoberera nzimukuse Anoni Anthony sokulaba nga oba oli awo tusaako embeera yonna nga awo ku bantu abali wano era abazze okulaba nga bagoberera n'okulaba nga oba oli awo bafuna ensala y'omusango Kizza ng'ayagala afuna eddembe lye lya okutaano. Naye nga eyo embeera yakategattako tuli wano tulinda ensalawo ya mulamuzi naye nga yo ensalawo okutegeeza nti yandibanga ya email oba ya mutimbagano oluvannyuma omulamuzi okuyita abamu ku bannamateeka n'abuuza nti lwaki muli wano, namutegeeza nti ekituleese kufuna rulingi ya Eron Kizza bategeezeddwa nti yaleero. Omulamuzi n'abuuza nti nabadde ensalawo ya besi namaze bayita sofa yeyambira bwetubweri era bannamateeka nabali bamusamye nemagaza tamanyi kiki kyebaza tamanyi eithaawameka
Never surrender. Never surrender. Never surrender. Never surrender. We shall overcome. We shall overcome. We shall overcome. I will be.
Singiza
Atula n'ekiti-shirt
Nancha size
So what do you want? Well, today we came to receive the ruling on the various applications that had been filed to seek the freedom of counsel Eron Kizza. First of all, the judge then first said that today was not the date for the ruling, and he stepped out. When he came back, Mr. Eron Kizza had been brought by the prison authorities. So eventually we ended up before the judge. The judge then asked whether we had complied with the service and filing of affidavits and written submissions, which on our part we confirmed. The state attorney claimed that he had not received some of the submissions. But then he said that in any event, the various applications all seek the same remedy, and apparently that whatever he had filed is enough to dispose of all the applications. The judge then asked us to summarize the gist of our argument, which we did. It's a very simple argument that all convictions and sentences by General Court Martial in respect of civilians like Eron Kizza, which were challenged, and in the case of Kizza by an appeal, were nullified by the Supreme Court. So we asked the judge to restore Eron Kizza's freedom by ordering for his immediate and unconditional release. The judge and the state attorney at some point were of the view that this matter should go to the criminal division of the High Court. And our reply was simple. The matter we had brought before the judge was not a criminal appeal. It was not a criminal revision. It was not to interrogate the sections under which Eron Kizza had been convicted and sentenced, but rather a matter to enforce the right of Eron Kizza to his freedom, a freedom that the Supreme Court had, in its ruling in the Kizza case, declared. So the judge has said Monday, 2 o'clock, to give his ruling. We hope that this time round it will be ready. It's unfortunate that this straightforward matter is taking us another one more week.
And so the statement maintains Council Eron Kizza is serving a lawful sentence in prison, and that any matters that were against him stand as is today.
No, there's no lawful sentence. Once the sentence was appealed, the judgment of the Supreme Court had a retrospective effect of nullifying that sentence. The word retrospective is a simple English word, which we believe that everybody understands. Something retrospective is that it works backwards. Okay? So, the effect of the judgment of the Supreme Court was to work backwards and nullify the conviction and sentence of Eron Kizza. And the simple thing we ask the judge is, can you make that order to release a lawyer who is in effect illegal detention now?
We do a break and back.
Ffenna tubadde tulowooza nti omulamuzi Justice olwaleero anaawaayo ekiragiro ekiyimbula Council Eron Kizza, naye tekisobose. omulamuzi ne Setatone balabise ng'empapula ezimu ze twateeka ku kooti tebanaziyitamu bulungi. Omulamuzi n'atusaba tumunyonyole mu bufunze nsonga ki gye tuleeta mu maaso ge. Ne tumunyonyola nti mu musango gwa Kabazikuka Supreme Court yasalawo nti omuntu yenna atali muserikale eyasingizibwa emisango n'asalirwa naye n'ajulira nti emisango egyo kooti yagimenyawo, n'olwekyo teri nsonga mu mateeka lwaki Eron Kizza akyali ekitale mu kkomera, era ne tumusaba amuyimbule. Omulamuzi atuwadde olw'ebbalaza olujja 8 okuwa ensala ye. Tusuubira nti kwolwo kanso Eron Kizza anaddizibwa eddembe lye. Ekyo n'okibuuza mulamuzi, kubanga ekimu kyabadde alowooza nti si yandibadde mu bitambo gy'omusango guno nti gwandigenze mu criminal division, naye tumumuwabudde nti Eron Kizza tazze kujulira, tazze kwemulugunya kawaayiro ki court martial ke yakozesa okumusalira, azze kutegeeza kooti nti Supreme Court yasazaamu ebyo byonna ebyakolebwa, n'olwekyo ab'ekkomera tebalina tteeka mwe bamukuumidde. So tekyetaagisa ate kumutwala mu criminal division kubanga tagenda kwewozaako, takyalina kyakwewozaako. So tusuubira nti omulamuzi olwaleero akitegedde bulungi, kasuubire nti anaatuwa ensala gye tusuubira, tunaalabagana ku Mande.
Kale ensonga nga muziwulidde ndowooza sijja kuziddamu kuzitemaatema badde muzigoberera bulungi ddala. Ebintu bitambudde olunaku lwaleero tusobola okuma wano ku Mande essaawa 8 ez'akawungeezi. Oba oba oli awo tunafuna ensalawo oba ate wanaabaawo ensonga y'okwekwasa okusaba okuyimbulwa kwa mukulu oba kanso Eron Kizza owa Kizza Advocates ng'ono munnamateeka wa abasibe abalala Kizza Besigye ne Haji Obed Mutale. Kale musikirize berekereze naye nga mbeebaza kubanga badde naffe okuba tutandikidde okutuusa wano. Nze mukose Arnold Anthony nga mbadde butereevu ku Alternative Uganda TikTok TV, era nga tubaagala nnyo, mwebale nnyo, mwebale ddala, temujjanga okwo. Mubeere bulungi, Mukama Katonda batukuumire, mweraba.
Weebale kulaba KKTV.